Morning, everyone. Today's session is on principles of contract law. My name is Shazia Khan, and the unit we'll be doing will have 4 learning outcomes and an assignment discussion. So I'll just go through the unit specification as it's a new unit that we'll be doing on principles of contract law. The unit is a level 3 unit. And the unit reference number is listed on the module specification, which you can find the unit specification, which you can find on Moodle as well, which is available for you. The unit grading is a structure. Structure is a pass or a fail. And so we'll just go through the module specification for the unit, and then you've got an understanding, and then we'll start with learning outcome 1 today. So this unit aims to cover what is meant by contract law. So we'll look at elements of contract law. What is contract law? And what is contract law in regards to what how a contract needs to be written, what there must be to identify that a contract exists. And you look at key terminology, what forms part of a contract, so express and implied terms, and you look at how contracts can end, including breaching a contract and any sort of remedies for breach as well. So the 4 learning outcomes we're going to go through is the first one is to understand the principal requirements of a binding agreement. And that's what we'll be doing today. Okay, the assessment criteria for that is to look at, the learner can look at 1.1, which is define what a contract is. 1.2, outline how to make a legally binding offer and acceptance. 1.3, to identify how often acceptance may be withdrawn. 1.4, explain the how to enforce a contract. And 1.5, explain the terms, invitation to treat and the intention to create legal actions, relations. The indicative content for learning outcome 1 is contract agreement, obligations, enforcement under the law, identifying parties to a contract, so who is involved in the contract, making an offer acceptance, and looking at the how it's communicated, and also giving case examples such as Carlisle and the Carbolic Malt Well Company, which was a really old case on communicating offers and acceptance. ITT, pharmaceutical case, and Boots, which we'll be looking at a little bit in learning outcome 1. We'll also look at the postal rule exceptions, electronic acceptance and the postal rule, revocation of an offer, withdrawing acceptance before or receipt of acceptance, privity of a contract, consideration, promissory estoppel, intention to create legal relations, rebutting the presumption to create legal relations with reference to cases and honour clauses in business relations. So that's all in learning outcome 1. The next learning outcome is learning outcome 2, which we'll look at understanding the principal contents of a contract. 2.1 will outline statutory express terms. 2.2, explore how representation is different from a term. 2.3, to explain how terms can be incorporated into a contract. 2.4, to explain contract conditions, warranties, and inanimate terms. 2.5, to explore how terms can be implied in common law. And 2.6, to evaluate the validity of exclusion clauses. And the indicative content for that will be looking at representation and what factors the court take into consideration, express terms, methods of incorporation, and terms implied by custom, trade, and usage. We look at conditions with reference to case law, and also look at common law incorporation of exclusion clauses and statutory governance. And we look at the Unfair Contract Terms Act and the Consumer Rights Act as well. In learning outcome 3, we'll look at understanding the principal factors that may vitiate a contract. 3.1 will look at outlining the various types of contractual mistakes. 3.2, outline different types of misrepresentation. 3.3, explain how a contract can be discharged. 3.4, we'll look at how explaining how lack of capacity, illegality, and public policy may void a contract. And 3.5, to summarise how undue influence and duress may void a contract. We'll be looking at elements of capacity to enter into a contract, minors, intoxication and intention to create legal relations, a meeting of the minds, contract voids in regards to public policy, including things like prenuptial agreements, statutory illegality, misrepresentation, fraudulent, innocent, and negligent, and the consequences of that. We look at Misrepresentation Act 1967, mistake, common mistake, mutual, unilateral, the effect of mistake, and frustration of a contract. Then we'll finally go on to learning outcome 4, is to understand how a contract may be breached. And we'll look at 4.1, which is to outline the effect that a breach has on a contract. 4.2, describe the role of equitable remedies in a contractual breach. And 4.3, to discuss types of contract breach, including anticipatory and repudiatory breach. And 4.4, to explain the meaning of damages in relation to contracts. And 4.5, to analyse what remedies are available for breach of contract. And the indicative content for learning outcome 4 is to look at breach of contract by one or more parties, anticipatory breach and repudiatory breach, the effect of breach of contract on remaining contractual duties, liquidated damages, clauses and penalty clauses, how damages can be calculated. We'll also look at equitable remedies and requirements for accessing equitable remedies. So to achieve, because the unit is just a pass or a fail, and to achieve that, the learner must demonstrate they fulfill the learning outcomes and meet the standards. And that will be in the assignment once we've gone through the assignment. So the learning outcomes that need to be met are learning outcome 1 to 4, and all the assessment criteria from learning outcome 1 to 4. And the type of assessment is a coursework, and it's 2,500 words. Then some of the reading list indicative content is just here that you could go on and have a look. There may be ebooks available on Moodle for you as well. This module specification is available on Moodle for you to have a look at, and any sort of additional resources. I'm just going to give you a quick overview of the assignment as well, because just to show you how it looks. So then we've got the final session. So we have the 4 learning outcomes, then the final session is assignment discussion, which will be discussed more there. So this is the assignment brief, and this is available again on Moodle for you. It goes through the learning outcomes with you, with the assessment criteria and what needs to be covered and what the learner needs to cover. But then it goes into the tasks. So there's 3 tasks which we'll go through in more detail in the assignment discussion session. Also, have a look at this so you've got an understanding of what is expected of you when you are completing the assignment. So this is how the assignment brief looks. It's available on Moodle for you. So please have a look at it in your own time, okay? And this will be more discussed in the final session, which is after the 4 learning outcomes. So I'm just gonna share the slides with you now. So the learning outcome now that we'll be doing today is learning outcome 1, which is looking at understanding the principal requirements of a binding agreement. So the unit covers what is meant by contract through offer, acceptance, invitation to treat, and students are introduced to key terms, things like express terms or implied terms. And the unit will cover how a contract can be formed, and it will go to how it ends, and also looks at remedies and breaches as well. So the indicative content for learning outcome 1, which I just went through on the module spec as well, it's looking at an agreement enforcement under the law, identifying parties to a contract, invitation to treat and offer, the postal rule, electronic acceptance, revocation of an offer, withdrawing acceptance before offer or receipt of acceptance, with reference to cases, counter offer, privity of contract, consideration, promissory estoppel, intention to create legal relations, and rebutting the presumption to create legal relations, and honour clauses in business relations. And all this we'll be going through with reference to case law as well, and that will be expected of you when you do your assignment as well. So firstly, what is contract law? Contract law is a really important part of the UK in regards to businesses and ensuring that's fairness within, between parties, because, it has evolved over time through common law and contract law looks at things like, making sure that, contracts are fair for businesses and making sure it's enforceable and it's a contractual agreement. So when we go on to look at what a contract is, it is literally a legally binding agreement between two or more parties. For a contract to be valid, there must be certain essential elements of that which we'll go through. So acceptance, offer, consideration, intention to clear legal relations, and and then like it says there, it's a fundamental part of any commercial activities, from buying or selling products and services to other, using software, renting property. So it's really, really important part of the UK economy. So there is a video there for you to have a look at in your own time, and it looks at the element of identifying what a contract is and what are the elements of a contract. So to understand the principal requirements of a binding contract is really important to make sure that you identify that, a binding contract must come into place where the, elements of the requirements are met, for a binding contract to become a binding contract. And it's an agreement that it should be a legally binding agreement between both parties, which is enforceable by law. And, there must be principles in place that you must follow before it identifies that a contract is formed. So the first element of it is really important element of a contract, which is offer. So which we'll go through in regards to that. So you've got an idea of what it is. So in contract law, let's go back to that. So offer and acceptance. In contract law, the offer is essentially starting point of any agreement, excuse me. An offer must be communicated clearly and include specified terms. And that could be things like, the quantity, the price, subject matter of the contract. When you communicate an offer, it must be directed to a specific party and made with the intention to create a legal obligation. The offer can be made either verbally or in writing. Following the offer, the other party has the option to respond. And in that element, that is where acceptance must mirror the terms of the offer. So if any adjustments or conditions are added, that constitutes a counter offer rather than acceptance. For acceptance to be valid, it must be communicated effectively back to the offerer. The methods of acceptance can be things like it could be done via a verbal agreement, it could be a written confirmation, or it's conduct that indicates acceptance. Once an offer has been accepted, a contract is formed, and then parties are legally bound to fulfill that respective obligations. However, there are nuances regarding timelines for acceptance and the methods of delivery that can affect the validity of acceptance. Offer and acceptance are the main foundation of any contract law that describes the process through which parties enter into a legally binding agreement. As we say, an offer is a proposal made by one party to another indicating a willingness to enter the contract, and the acceptance occurs when the offeree agrees of the terms presented in the offer, which finalizes the contract. So they are the most important elements of it. So next one is consideration. So consideration is something that has value in the eyes of the law. It is an essential element of forming a valid contract. In practice, there must be exchange of valuable things for legally binding contract. Consideration is one aspect of the contract forming process and is necessary for every new agreement to be enforceable in law. It is really important to know that consideration must be present when the contract is formed. Past consideration of something already done before the contract was made is generally not considered valid consideration. So that is really important to take into consideration when, looking at the element of consideration, why it's so important when it comes to identifying a contract. Consideration is one of the key elements of that. The only way a contract without consideration will be enforceable contract if it's made by deed, which is a written document executed with the necessary formality. So, there are key points about consideration. Consideration is a promise or a promise not to act. This means that some value must pass from each party to the other for the agreement to become legally binding. It need not be adequate, but must be sufficient. It must not be historical, as we mentioned, and it must move from the person making the promise. Then we've got to look at the element of intention to create legal relations. Intention to create legal relations is a fundamental principle of contract law, where both parties must intend for the agreement to be legally binding. The concept outlines the necessity for parties involved in a contract to have the intention, as we mentioned, to be legally bound by the terms of the contract. So it could be whatever terms are put in place then. If there is no intention to create legal relations, the contract may be rendered void or unenforceable. This principle helps to distinguish between social and legal agreements, ensuring that only those agreements intended to have legal implications carry such a weight in the court of law. The definition of intention to create legal relations can be bifurcated into two categories: social agreements and commercial agreements. Each exhibit different presumptions regarding the intent to create legal relations. So the social agreements, these are typically informal agreements made among friends or family where there's generally no intention to create legal relations. For example, an invitation to dinner is not legally binding. And then commercial contract. In contracts, commercial agreements are presumed to have an intention to create legal relations. In these situations, the parties involved are expected to be legally bound by the agreements, such as a contract for the sale of goods. The next one we're looking at in regards to elements of it is capacity. So in contract law, capacity is a fundamental concept in regards to contractual agreements and whether they are valid or not. Capacity refers to an individual's legal ability to enter into a contract. In simple terms, it's consideration of whether a person is in the right state of mind, so whether they're in the mental capacity and have the right state of mind, and has the legal competence to commit into a legally binding contract. So they have to be of sound mind, they have to be a certain age, and they have to be mentally, they have to have a mental state. The capacity to contract in the UK is largely determined by common law that has evolved through judicial decisions over a long time. The common law recognizes certain categories of individuals who may lack the capacity. These principles are now well established. So this is capacity is really, really important in contract law because it protects vulnerable parties, and it also ensures that voluntary consent has been given, and it upholds things like legality as well. So, it constitutes, capacity to a contract typically hinges on factors such as the age of majority, mental capacity, intoxication, and whether the person is has the capacity to make that legal contract. Then we've got the element of the next one is certainty. And the concept of contract certainty holds significant importance in any sort of agreements or transactions. Certainty in contract law refers to the clarity and precision of terms and conditions within a contractual agreement. All parties involved in a contract need to be fully be able to understand and interpret its terms. They need to be able to understand what they are, signing. A contract can be complete and final agreement, leaving no room for ambiguity or misunderstanding. So it needs to be clear because, when we look at certainty, It's one of the cornerstones of legally binding agreement. You must be able to understand the terms that are put in place, and you must be able to understand what you are signing. Next one is a legality of purpose. In contract law, legality of purpose means that a contract is only enforceable if its intended objective is legal and does not violate any laws or public policy. Essentially, the contract's purpose must be lawful to be considered valid and binding. If in any term the contract is illegal, the contract is then void and unenforceable. So formalities of a contract. Formalities refer to the essential elements that must be present for an agreement to be considered a legally binding contract, including the offer, the acceptance, consideration, intention to create legal relations. Essentially, both parties must provide of value in exchange for other parties promised and must intend to be legally bound by the agreement. Contractual formalities are there to serve as a guide to the parties against any sort of unforeseen circumstances that may lead to litigation. They serve to protect the parties under concluding a legally binding contract and serve as proof of a dispute of facts arises from the contract. And examples that have been given on the slide is the real estate transactions typically require written contracts, and contracts under the statute of frauds or specific laws must be adhered to prescribed formalities. Examples of binding agreements, things like it could be employment contracts, employment lease agreements, purchase agreements for real estate, loan agreements, service contracts. So it could be business agreements that are binding. And on that list, it said things like commercial agreements, employment agreements, and lease agreement as well. So these are legally binding agreements that need to be put in place for anything to happen. So 1.1, looking at the definition of a contract. So as we said, a contract is an agreement between parties creating mutual obligations that are enforceable by law. The basic elements required for the agreement to be legally enforceable are mutual assent, expressed by a valid offer, acceptance, adequate consideration, capacity, legality, and supported by consideration as well. And this is where a legally binding agreement will take place then and is formed. Key elements of a contract, and we've discussed them a little bit earlier on as well. So an agreement is the first one, and that's an agreement between both parties. Obligations, duties of the parties to fulfilled as part of the contract. Enforcement, contracts are enforceable by law. Parties can seek remedies through the courts if they are not followed. Consideration is something that is of value exchanged between the parties. Legality is something that the courts must have a lawful purpose and not involve illegal elements. Capacity, that the both parties have the capacity, and intentions, that the both parties intend to create this legally binding agreement. Explanation of each key element. So you've got an agreement. This is a foundation of the contract, which mentioned on the slides on the table as well. Contracts specify which party is obligated to provide such delivering goods or making a payment, and the enforcement under law if meets all the legal requirements. If party fails to meet the obligation, they would need to apply for legal remedies and go to the court. Example of a contract: employment contract and a lease agreement. An example of employment one is an employer agrees to pay a salary in exchange for employees' services. Lease one, and landlord rents property to a tenant in return for a fixed monthly payment, and that is agreed in a contract. How to make a legally binding offer, and that's 1.2. The basic fundamentals of a contract, that it must include offer, acceptance, outlining which is provided and an acceptance of that offer. There must be something of value exchange, and which could be a service, sale of goods, money, or even a promise to provide one of the things. So identifying parties to a contract. So to create legal binding contract, the parties are involved in this contract. So identifying parties to a contract, you look at for the names of the individuals, companies, or organizations, explicitly stating in the contract document as parties. And these would be the parties involved in that contract, and the capacity that each party must have the legal ability to enter the contract, and they must not be minors, so must not be under the age of 18. Making a legally binding contract. To make a legally binding offer, you must clearly state your proposal, including all the essential terms, and communicate it to the other party with the intention to be bound by the acceptance, ensuring elements like consideration, capacity of the parties involved, and the legality agreement are present. Essentially, you need to present an offer that outlines what you are willing to provide in exchange from something from the other party, and it must be clear acceptance. So here it needs to be the element of clarity, definedness, voluntary nature. So for example, a shop offering to sell a product for £50 is making it clear and definite offer. The next one is element of communicating an offer. And it's really important to communicate an offer, to the element of, this is one of the elements of it. An offer can be only considered valid after it's communicated to the offeree. Communication of the contract is only complete when it's conveyed to the other party and accepted by them. The offer can be dispatched through any forms of communication, and key methods are things like, verbal communication, written communication, or digital communication, or through word of mouth as well. These are elements and key methods that are used to communicate an offer and accept it. Acceptance of an offer. And this is where, as we mentioned earlier, is where the offer is accepted, and it's the final and unqualified agreement to the terms of an offer. They have elements of that can be identified. So you can have key elements. It could be unconditional offer, and this acceptance must be without any changes or variations to the original offer. Communicated, so the acceptance must be known to the offerer. And method of acceptance, that the acceptance is verbal, written, or through conduct. So these are the requirements of acceptance of an offer. And it's really important. Accepting an offer must be communicated to the person who's made the offer, so that person understands, and generally in a way that can be unambiguously interpreted as acceptance. If the terms of an offer are such that they cannot be accepted, then it is said to be rejected, and offers can either be definite or indefinite. Summary of table. So this table identifies steps like identifying the parties, which the description is clearly identifying who's involved in the contract and confirm that they have the capacity, so the mental capacity to enter into that contract. Making an offer, so making it clear and definite. Proposal, outlining the terms of the agreement. Communicating the offer, ensuring the offer is communicated through verbal, written, or digital methods. And then acceptance can be unconditional, as we mentioned, and it needs to align with the terms of the offer. So we're looking at now 1.3, how offer and acceptance may be withdrawn. So an offer can be withdrawn or revoked at any time before the offeree, which is the person receiving the offer, communicates their acceptance, meaning the offerer can take back the offer as long as the party hasn't formally agreed to it. Acceptance can also be withdrawn before it is communicated to the offerer, effectively rejecting the offer. And these were some of the important cases of offer and acceptance. Carlisle and Carbolic Smokeball, 1893, and the Pharmaceutical Society of Great Britain versus Boots, 1953, and Adams and Linsell, which we'll go through later a little bit. Accepting an offer. The acceptance is unqualified agreement to the terms of a contract, creating a binding contract. However, understanding when acceptance can occur, when it can be withdrawn, things like communicating of acceptance, method of acceptance. It could be verbal, as we said, it could be digital, it could be communicated through word of mouth. And the really important case in regards to that, as we mentioned, is the case of Carlile versus Carbolic Smoke Ball case, 1893. And in the case was the defendant, the Carbolic Smoke Ball Company, placed an advertisement in a newspaper for their products, stating that any person who purchased and used their product but still contracted influenza, despite properly following the instructions, would be entitled to £100 reward. The advert further stated that the company had demonstrated its sincerity by placing £1,000 in a bank account to act as the reward. The claim, and Mrs. Carlile then thus purchased some smoke balls and, despite proper use, contracted influenza and attempted to claim the £100 reward from the defendants. The defendants contended that they could not be bound by the advert as it was an invitation to treat rather than an offer, on the grounds that the advert was mere puff and lacking true intent, and that an offer could not be made to the world. The claimant had not technically provided acceptance. The wording of the advert was insufficiently precise, and there was no consideration as necessary for creating of a binding contract in law. The issue here was whether the advert in question constituted an offer or an invitation to treat. And the court said in this that the Court of Appeal found the claimant determining that the advert amounted to the offer for a unilateral contract by the defendants. In completing the conditions stipulated by the advert, Mrs. Carlile provided acceptance. The court further found that the advert's own claim to sincerity negated the company's assertion of lacking intent. An offer could indeed be made to the world. Wording need to be reasonably clear to imply terms rather than entirely clear, and considerations was identifiable in the use of the balls. So this case was in 1893, but this case is quite famous in regards to identifying whether an offer and acceptance was made in this element of this case. So the next one is invitation to treat. So we look at invitation to treat and offer. What is the difference between each element of that? So an invitation to treat is a legal concept in contract law that refers to an indication that a party is willing to negotiate the terms of a agreement. It does not constitute an offer in itself, but rather invites others to make offers. Common examples include things like advertisement, auction listing, or items displayed for sale in the shop. This means that when you see an advertisement for a product, the seller is not committing to sell the product at the advertised price until an offer is made. The seller can then accept or reject the offer. It's important to understand the distinction between both of them. The primary difference between an offer and acceptance, offer and invitation to treat, lies in its legal consequences associated with each one. Firstly, it looks at the nature of the commitment. So an offer indicates a commitment to enter a contract upon acceptance, while an invitation to treat is simply an invitation for offers. The legal standing. Once an offer is accepted, a legally binding contract is formed. As an invitation to treat does not create any binding obligation until an offer is accepted. For instance, a person placing a product in a store with a price tag is making an invitation to treat. In contrast, a customer saying they want to buy the product at the listed price would be them making an offer. So these kind of examples, you'll get examples like advertisements in stores, store displays, auctions, maybe any social media promotions as well. And then and scenarios that it could be things like menus in a restaurant, where someone goes in and they're considered looking at the menu and different prices, and that could be an element of it as well. The important case in regards to that is the case of the pharmaceutical company Society of Great Britain and Boots, 1953, which looked at an element of invitation to treat and looked at the element of an offer. and identify the difference between it. The next one is looking at the element of postal rules and why they are so important in regards to contract law. So the postal rules is a contract principle that governs situations in which acceptance is not made in person and where the contract or offer does not specify the method and timing of acceptance. In summary, the postal rule dictates that acceptance of an offer made by letter and sent by post is effective upon postage of the letter. This can cause problems as this position will be maintained even if the letter is delayed or lost in the post. Further, there's a reception rule, and this rule states that acceptance occurs once the offerer receives the acceptance. While the postal rule originated when letters were the primary method of communication, its relevance persists in specific circumstances. In today's businesses often rely on instantaneous communication, things like, the fact that we have such as email, messaging apps, and video conferencing. In this case, the general rule of communication applies. Acceptance must be communicated to and received by the offerer to be accepted. Where acceptance is by email, either the postal rule or the reception rule could be applicable because although email is generally instantaneous, they can delay in some circumstances. Businesses should specify the acceptance methods of timing of acceptance in their contract to reduce any sort of ambiguity. So the cases that in regards to postal rule are things like Adam and Linsell, which it was about a letter being sent out and when they accepted that and when the offer was made. The next one is looking at elements of electronic acceptance and the postal rule. So when we look at electronic acceptance and the postal rule, in contract law, the postal rule states that acceptance of an offer is considered effective as soon as it's posted in the mail, even if it is lost or delayed. But this rule generally does not apply to electronic communication, like email, as I mentioned earlier, where acceptance is typically considered effective upon receipt by the offerer due to the instantaneous nature of electronic communication, meaning a contract is formed when the email is received, not when it is sent. So, these are elements of that, the fact that, if someone sends a contract via an email and the other party replies with an email acceptance, the contract is formed when the offerer receives an acceptance, receives the acceptance email, not when the accepting party hits send. Okay, so these are electronic acceptance and the postal rule. The next element of it is on the handout on the slide is revocation of an offer. And this means that the person who made an offer, the offerer, is withdrawing or cancelling the offer, making it no longer available for acceptance by the other party, which is the offeree. Essentially, it means that the offerer is taking back their offer before it has been accepted, effectively ending the possibility of a contract being formed based on that offer. Key points about revocation of an offer are things like the timing is really crucial, so offer can be only revoked before it's accepted by the offeree. Communication is really important because the offerer must effectively communicate their intention to revoke the offer to the offeree for it to be considered revoked. And once an offer is revoked, the offeree is not obligated to accept it and they cannot form a contract based on the withdrawal offer. Examples of that could be a job applicant receives a job, but it's later informed that the position is no longer available due to budget cuts, or a business offers a special deal on a product and then decides to withdraw the offer before the promotion ends. So withdrawing acceptance. So in contract law, withdrawing acceptance refers to the act of trying to cancel an acceptance of an offer, which is generally not possible once the acceptance has been communicated to the offerer. Essentially, once you accept an offer, you cannot later withdraw the acceptance unless specific conditions are met, like a mistake or fraud involved, and this is usually considered a breach of contract. So key points before communication or before receipt. So exceptions to the rule are misunderstanding or mistake, as we mentioned, fraud or duress, or conditional acceptance. So this is a summary table of what we've discussed. So acceptance, invitation to treat, postal rule, exceptions to postal rule, electronic acceptance, revocation of an offer, and withdrawing acceptance with reference to the description. And some in the diagram in the table, it identifies cases that you can look at for each element of that. How to enforce a contract. So to enforce a contract in UK, you can take legal action by filing a claim at the county court to, with legal requirements. Key principles such as counter offers, privity of contract, consideration, promissory estoppel, intention are crucial in determining whether a contract is enforceable. So you need to make sure that elements of the legally binding contract are in place for the contract to be enforceable, as we mentioned, offer, acceptance, consideration, capacity, and intention to create legal relations. They are a crucial part of a contract. Counter offer, destroying the contract. So counter offer effectively destroys the original offer by acting as a rejection of it, meaning that once a counter offer is made, the original offer can no longer be accepted and considered void under contract law. Essentially, proposing a new set of terms automatically negates the previous offer on the table. And the case in regards to that was a Hyde and Wrench case in 1840, where the defendant offered to sell a farm for £1,000. The claimant made a counter offer £950, which the defendant rejected. When the claimant later tried to accept the original offer, it was no longer valid because the counter offer had been destroyed. Key points about counter offers and destroying original offers. Rejection mechanism. So when a counter offer, when you make a counter offer, you are essentially saying no to the initial offer and proposing different terms instead. A counter offer is not just a request for clarification. It is a new offer with modified terms. So you can't just think it's the old offer, which is the other party can then choose to accept or reject. Once a counter offer is made, the original offerer cannot later decide to accept the initial offer as it's no longer valid. And that happens sometimes. People will go back and forth. So here, an example is a seller offers to sell a car for £10,000 and the buyer responds with a counter offer £8,000. By making the counter offer, the buyer has effectively rejected that original price of 10,000 offer, and the seller can only accept the 8,000 counter offer or negotiate it further. So, it doesn't mean it will go back to the old offer. So privity of a contract. So privity of a contract means that the other parties who signed a contract can enforce its terms, meaning a third party who is not named in the contract cannot sue or be sued based on the provisions unless specific exceptions are made under the Contract Rights of Third Parties Act 1999. Essentially, only those directly involved in the contract have legal standing to claim rights or obligations under that. Key cases, Dunlop Pneumatic Tyre Company and Selfridge Company Limited, 1915. Key points about privity of contract in contract law is that only parties to a contract can sue or be sued for the breach of contract. The Contracts Third Parties Act 1999 allows a third party to enforce certain terms of a contract in specific situation, but this is not automatic. When an important part of drafting in privity of a contract is when drafting a contract, it's crucial to explicitly state if a third party should have enforceable rights under that contract. So it's really important that you identify that in the contract when you do that. Again, consideration is a fundamental requirement of contract law, and it is something of value exchange between the parties, as we mentioned. And it could be money, it could be property, service, work, it could be or a promise to not do something. So it's really important element of any sort of contract. And you can have different types of contract. You could have a promise to do something, as we said, or promise to refrain from doing something. Consideration is able to be minimal, such as £1 in certain instances. Consideration contracts supported by small consideration are enforceable because the courts will look for consideration for a promise rather than examine the commercial merits of the contract. Courts also are reluctant to interfere with contracts which are freely made between contracting parties. If the parties performed, if it's performed, promises are performed at a later date or time, the contract is made, but it is sufficient. The consideration really is important in any sort of contract when it comes to elements of forming a contract. So promissory estoppel. So promissory estoppel is a legal doctrine that prevents a party from going back on a promise they made to another party. And it's used when a promise is made without consideration, but the other party relied on it. The defendant needs, when it promissory estoppel works, the defendant makes a clear and unambiguous promise. The plaintiff relies on that promise, and then the plaintiff reliance was reasonable and foreseeable, and the plaintiff suffered an injury due to the reliance of that onto that promise. And it refers to the doctrine that party may recover on the basis of a promise made when the party's reliance on that promise was reasonable and the party attempting to recover detrimentally relied on that promise. So, you know, there are main elements of it. You know, there are elements that need to be considered by the courts when they look at promissory estoppel, identifying that the party can't just go back on the contract. You know, it's really important in that element in regards to making a promise. And you know, there's a really important case in regards to that, and it's the Central London Property Trust Limited and High Trees House Limited, 1947, which is the leading case for promissory estoppel, and also gives you a clear example of the principle in that case. So if you look at that case, you know, it identifies a clear example of it. The next one is intention to create legal relations. And again, for a contract to be enforceable, there needs to be legal relations in place, you know, and they need to make sure that, you know, there's a legal contract in place. And business agreements is a presumption exists that business agreements are intended to be legally binding unless explicitly stated. And this is, which we'll go through, is through honor clauses in a contract. And a social domestic, there's a presumption against legal enforceability in social or domestic arrangements. And the key case for that is the case of Jones and Padavaton, 1969, where a mother promised to support her daughter financially if she studied law. When the agreement broke down, the court held that it was a domestic arrangement with no intention to create any sort of legal relations between them. The next one is honor clauses in business relations, and a business statement, an express statement in a contract that an agreement is intended to be binding honor only. So the courts usually allow it to take effect and enforce that. When it comes to on a contract, here you are bound by contracts that are statements in contracts that exclude legal enforceability. And an example is a written agreement may state if that it is binding in honor only, indicating that parties do not intend legal enforceability. So this summary table identifies things like what we've looked at, the concepts and the description and the key cases and principles. So we looked at counter offers, privity of a contract, consideration, promissory estoppel, and we looked at intention to create legal relations and honor clauses. And we looked at them with reference to their description, and that table identifies that, and key cases such as Hyde and Wrench, Dunlop and Selfridges, and Jones and Padavatten, 1969. So this table gives you a little bit of an overview at the end of it, what we've done in regards to that. So explain the terms invitation to treat and the intention to create legal relations. So invitation to treat is a primarily a preliminary statement or action that invites someone to make an offer, essentially initiating negotiations without creating a legally binding commitment. While intention to create legal relations refers to the mindset of parties involved in an agreement, indicating their willingness to be bound by the terms, meaning they intend the agreement to have legal consequences if accepted. So just breaking it down and looking at invitation to treat first. Invitation to treat, this is not concrete offer, but rather an expression of willingness to discuss potential terms of a contract, like displaying goods in a shop window, advertising prices, or a restaurant menu. The party making the invitation to treat is not obligated to sell or agree to any terms presented. They're simply inviting further negotiations. And an example is a price tag on a product in a store is considered an invitation to treat, as the customer can choose to purchase it at the price, but the store is not bound to sell it until the customer makes an offer. Whereas if we look at invitation to create legal relations, this is signifies that the parties involved in an agreement understand that their words and actions are meant to create a legal enforceable contract. Courts will consider factors like the nature of the agreement, the relationship between the parties, and the language used to determine if there was a genuine intention to create legal relations. And an example of this is in a formal business contract, the intention to create legal relations is usually presumed as both parties are expected to be bound by the terms outlined. So it's really important to identify the element of that and the differences between that. So when we looked at intention to create legal relations, we've looked at things like that. So key principles is commercial agreements and domestic agreements in that. So this diagram here, this summary of table, identifies comparison of looking at invitation to treat and intention to create legal relations as well. So it looks at the definition of intention to create legal relations, which is that refers to the intent of parties to enter into legally binding agreement. And it helps distinguish between social and legal agreements as well. The purpose, it encourages from others invitation to treat cases, Partridge and Crickington, Boots Chemist, and examples advertisements or goods on display. The intention to create legal relations, the definition is requirement for parties to tend in legal enforceability. The purpose ensures agreements are enforceable by law. Cases are Jones and Padavatten, 1969, Rose and Franco and Cropton, 1923. Examples, commercial contracts, written financial arrangements. So now that we've finished learning outcome 1, these are some of the references that we've used for learning outcome 1 in regards to what we've discussed in today's session. I'll just give you an overview of what we've done, a summary of what we've done in today's session, which is learning outcome 1. So we've looked at elements of a learning outcome, which was to understand the principal requirements of binding agreement. We looked at elements of contract agreement obligations under the law. We looked at identifying parties to the contract. We also looked at making an offer, going through the elements of a contract, acceptance, consideration. We looked at invitation to treat and an offer with reference to cases such as the Carlisle and Smokeball case, pharmaceutical, Adam and Lindsley. We looked at the postal rule and the exceptions to the rule. We also looked at electronic acceptance and postal rule, revocation of an offer, withdrawing acceptance before offer acceptance, counter offer. We looked at destroying original offer and the case of Hyde and Wrench, privity of a contract. We looked at consideration. We looked at the case of Dunlop and Selfridge, 1915. We looked at promissory estoppel, the intention to create legal relations. We looked at rebutting the presumption to create legal relations in social domestic relations, and looked at the case of Jones and Padavatten, 1969, and we looked at honour clauses in business relations and identified that. There's also a video available at the start looking at what is a contract and looking at the elements of a contract. These are the references we've used for today's session that you can go on, which will help you further elaborate on certain concepts. Preliminary, if you've got, refer to ebooks and journals on Moodle, please, because they are available for you. All these recordings will go on Moodle for you. Any sort of additional reading is on Moodle available. The module specification, the assignment brief is available on Moodle, and all the slides are available with the recordings on. I've put a link there for any sort of, it's an article on contract law and the basics of contract law, and it's a PDF article that you can read, so put that in and have a look at that, because that will help you towards working around certain concepts on your assignment. If you have any questions or any inquiries to make, email learnerwork@ukvarsity.co.uk. Submission of the assignment is to be done 2 weeks after the assignment discussion session. So we'll have we've got the next learning outcome, which is learning outcome 2, 3 and 4, and then we will have the assignment discussion, and it's 2 weeks after that. If you have any questions, again, email learnerwork@ukvarsity.co.uk. Thank you for attending today's session. Thank you.